Good afternoon and welcome to Tiffany's Teach Tuesday. I am today, as I told you guys last week and been discussing all this month, that I was going to bring out an attorney to talk to you about building, keeping your generational wealth building and passing it on to others. A lot of times people build an estate, however, they fail to put the proper legal things in place to ensure that it passes on to their heirs without them disputing over it, ending up in probate court. So today I'm going to bring to you Denise Russo, who is an attorney, an estate planning attorney, and actually she was my estate planning attorney that helped me put my affairs and my mother's affairs in order to ensure that when we leave this earth or if something happens to us, that our family will know the directives of how we want things to be done. So I'm going to bring her on now so she can tell you more about herself, and we're going to get started with the questions. Welcome, Denise. I can't hear you. Can you hear me? I can't hear you. You got me on mute? No, I can't hear you now. She just disconnected. We're having a little technical difficulties. Just give us a moment. Hello? No, I can't hear you at all. No, I still can't hear you.
Can you hear me now? Tiffany, can you hear me now?
Yes, I can hear you.
Can you hear me now?
Yes.
Whew. Sorry about that. Well, thank you so much for inviting me today to speak with you. I really appreciate the opportunity. You know how passionate I feel about this subject matter, so.
Yes, I do. So if you want to tell them a little about yourself.
Sure.
And what made you get into estate?
Sure. So I'm an attorney. I am licensed to practice in the state of Illinois as well as the state of Texas. I've been practicing law. I've been practicing law for over 20 years, and I started my career in a completely different legal field than estate planning, and I started practicing in estate planning in 2005, and it was a very personal decision for me to practice estate planning. I had the experience of losing both of my parents within a period of a year. And when one parent died, they had everything tied up in a nice, neat little bow, and it made everything very easy for me to administer. And the experience that I had with my other parent was the complete opposite. There was no plan. There was a lot of family discord, a lot of fighting. And after that experience, I realized what an impact estate planning can have on an individual's personal and family situation. So I decided to focus my practice on estate planning, and I've been doing that ever since 2005.
Oh, wonderful. So I'm going to ask you a few questions that my watchers, my viewers will to you, and then you put in information, the question I answer when I ask you the first two questions.
Okay.
So what is a trust? Because we've been talking about trust. I've been explaining to them because let me go back. All of this month we have been talking about building generation and the way to build it. You know, the different avenues to build generational wealth. However, what we didn't we discussed trust and building buying real estate of that nature. But I need them to understand the importance of making sure those assets that they've established and built, it flows directly to their people of, the heirs of choice without having to go to probate court and them understanding what is a trust. Because a lot of people are like, oh, I got a will. And it's like, it's a difference between the two. And a lot of people think that the will will help them. So I want you to explain what is a trust and the difference between a will and a trust.
Excellent. So you said some of the differences when you just talked, but I think that that is the key, is to start with the difference between a last will and testament and a revocable living trust. Both documents are estate planning documents that outline how your assets are to be distributed in the event of your death. So a last will and testament is a document that says, in the event of my death, I leave everything to my spouse, and if my spouse doesn't survive, to my children. A living trust does the same thing. The difference is that a living trust allows you to avoid probate of your assets if you transfer assets to your trust while you are alive. So a living trust is primarily a probate avoidance technique. And the way that you avoid probate is, let's say you own real estate, you own real property, and your name is, I own a home, and it is deeded in the name of Denise Russo. In the event of my death, my home, because there's no one else's name on the deed, that home would need to be, that piece of real estate would need to be probated. And if I had a last will and testament, the real estate would be transferred or distributed to whoever I named as the beneficiaries of my last will and testament. If I wanted to avoid probate, I would create a living trust, and while I was alive, I would transfer that piece of real estate to the trust through a deed. In the event of my death, whoever I named as my successor trustee would have the authority to access that real estate and distribute it, either sell it or keep it or rent it or do whatever I said they were supposed to do in the trust. So it avoids the administration of your assets. It avoids court involvement in the administration of your assets, which is, probate is not a bad thing, but it is a court proceeding. And court proceedings cost money and they take time. And they're more costly and more timely the more assets you have and the more complicated your estate is. So when people own more than one piece of real estate, even if they own one piece of real estate, I strongly encourage them to create a living trust as their primary estate planning vehicle because of the avoidance of probate.
Okay. Are there different types of trusts?
There are different types of trusts. The two main categories of trusts are revocable trusts and irrevocable trusts. Revocable trusts are most of most types of trusts that I am dealing with and creating for my clients, and those are trusts that are created while you're alive, and you, as the creator of the trust, the person who creates the trust is called the grantor. The grantor retains control over the assets during life, and they can change the document or change the terms of the trust at any time. So a revocable trust basically means it can be revoked, it can be changed at any time, and most people, that's where they start out with a revocable trust. However, when the grantor dies, the trust becomes irrevocable and the terms can't be changed. Oftentimes, while people are alive, they create irrevocable trusts for the benefit of a beneficiary who has a special need or is disabled. That's a type of irrevocable trust. But most times people are creating revocable trusts because they don't want to, they want to be able to continue to manage the assets that are in their trust while they're alive.
Okay. What properties can go into the trust?
So you can transfer anything into a trust. That's anything that's legal. You can transfer anything into a trust. How you transfer the asset depends on what the asset is. So when it's real estate, for example, the way that you transfer it to a trust is through a deed. And you would deed the property in your name as the trustee of your trust. If you have an existing financial asset, the way that you transfer a financial asset to your trust is to name your trust as the beneficiary of that financial asset. If you have a business, the way that you transfer your business asset to your trust is through an assignment of business interest. And then once you have a trust, the beauty of a trust is that once you have created a trust, as you go forward in your life and acquire new assets, you then acquire them in the name of your trust. So you don't have to retitle or redeed anything, you just acquire it in the name of your trust. So if I have a trust and then 2 years from now I buy an investment property, I would, well, that's a bad example. I buy a second home, I would buy it in the name of my trust.
Okay. Who would you recommend for someone to make a trustee? And explain what is a trustee.
So a trustee is a fiduciary, and a fiduciary is a legal term which means someone who is acting in a position of trust. When you are named as a fiduciary, you owe a duty to the person that you are acting on behalf to act in the best interest of that person and in the best interest of the wishes of that person on who you are following. So it's a person in a position of trust. So the first thing that I advise people is you should name someone you trust, because that person needs to is responsible for carrying out your wishes and following the rules that you set out in the trust document. So their job strictly is to execute. They are not there to create or strategize. They're just to execute the document as you've set it out. There are times when people struggle because they don't have a family member that they trust to name as a trustee. I prefer naming a family member or a trusted individual, but if a family member is not available, then I encourage people to look for other trusted advisors, like if they do have an accountant or a financial investor or someone in the family who's an attorney and just is, would be trustworthy. So the most important thing is that you name someone that you trust, because that person will be responsible for administering your trust in the event of your death.
Now, what are the
there are, from my perspective, there aren't any drawbacks. Because particularly when you're creating a revocable trust, you can change the terms at any time. So if life circumstances change, if your family circumstance changes, you can always change the terms. So there's no drawback in creating a revocable living trust. The kind of barrier for people going from a last will and testament to a trust is mostly budgetary reasons. Trust is more costly from a professional fee standpoint than a last will and testament, because there's much more drafting that goes into a trust. So for some people, their budget does not allow them to use the services of an attorney to create a trust. But I always encourage people to think that the way to think about it is, if you pay for creating a trust while you're alive, you're essentially avoiding the cost of probate in the event of your death, which is a lot more expensive than creating a trust while you're alive. So it's kind of paying for it up front so that in the back end your estate doesn't have to pay costly court and probate fees and attorney fees.
So that was my question. Doesn't avoid the probate. So
it doesn't. A living trust can be an estate minimization tool for individuals who are in a taxable estate situation. And what I mean by that is both the federal government as well as the state of Illinois impose a tax on estates over a certain amount. The federal exemption is currently $11.4 million. So most people these days are not in a taxable estate situation from a federal standpoint. However, if you are a resident of the state of Illinois, the state of Illinois imposes a tax on estates over $4 million. So if you have a living trust, you can do some estate tax minimization planning in your trust document. It does, but there are no taxes associated with probate, but there are costs associated with probate. So a trust does avoid the cost of probate, which can be, particularly in Cook County, it can be costly. I mean, you're talking about thousands of dollars.
My next question. How can a person who live in trust themselves to people they can or need legal counsel?
So I don't like to, I'm an attorney, so I'm not going to tell someone to do it themselves. I think it's dangerous to do things yourself. I don't know how to, I don't know how to fix a toilet. I wouldn't try and do it on my own. So I could break something. I could cause more problems than I currently have. So I do encourage people to seek the advice of an attorney. I always tell people that I am document agnostic, and what I mean by that is whether you choose a last will and testament or a living trust as your primary estate planning vehicle, I do whatever the client, I create a plan based on what the client's planning goals are. I understand that sometimes people just can't afford to do living trusts, and I'm very happy to do a last will and testament for them. However, I do strongly encourage people who have at least one piece of property that they own only in their name, that they don't own jointly, or multiple pieces of real estate to consider living trust, because it really can seriously streamline the administration of their estate.
Well, I'll speak to my viewers. I always say, you get what you for. And at the end of the day, you have to decide financially if you can eventually afford it. Because a lot of times people feel they can't afford things, but they'll feel a lot of things that they don't. And just your priorities and perspective, especially if you build, because you own multiple property or one property, you have some form of income stream that will get afford to facilitate the execution of the trust for you. So how do you budget the things to make that happen? And I truly try to encourage ourselves to teach that we make financial decisions because it'll affect our outcome in the long run. My last thing before we go today, should a person have a will? Should a person have a will in trust, and do they still have power if they have?
Sure. So if you have a living trust as your primary estate planning vehicle, you also need a last will and testament, and that will is called a pour-over will. And a pour-over will is a special kind of a will that is used when an individual has a living trust as their primary estate planning vehicle. The reason why practitioners also provide a last will and testament is in the event that an individual has a living trust and they forget to transfer an asset to their trust while they're alive, there is a will to transfer the asset, to probate the asset, but the asset gets distributed according to the plan of distribution of your trust. So the trust becomes the roadmap for how all of your assets are to be distributed, and the will is there as a safety net. There have been times, I grill into my clients when I create living trust for them, the importance of ensuring that all of their assets are transferred to their trust. But there have been times where I've had clients who have died and they have living trusts, and their family members discover that they have a bank account that they never transferred to their trust, and the bank account has over $100,000 in it. Then that asset needs to be probated. So the will is used to probate the asset, but the asset gets distributed according to the plan of distribution of the trust. A will is also important for couples or families or parents who have minor children, because a will is the document wherein you name a guardian to take care of your minor children or your any children that are unable to take care of themselves because of a mental or physical disability. So it's also important to have a will for individuals who are parents who have minor children under the age of 18, so that they can name a guardian for a child.
I have a question for both sets. So I went to that workshop, and it was a attorney there that talked about a land trust. Mm-hmm. So if you have a living trust, what would be the benefits of the land trust?
So a land trust is a very old school way of avoiding probate of real estate. Years ago, land trusts were kind of the only way that when someone wanted to avoid probate, owned a piece of real estate and they wanted to avoid probate, they would put it in a land trust. And typically the way they did that was they would hire a company like Chicago Title and Trust or Northern Trust or some other third party, and that third party would create the trust, and that third party would be the trustee, and then you'd pay that third party a fee annually to maintain the trust. So it's an old school way of avoiding probate. The reason that there are some times where land trusts are beneficial, and that typically these days land trusts are used for large pieces of property like farms, where people want to keep them. They want to keep them in perpetuity in the family. But 9.9 times out of 10, a living trust is a much more flexible tool than a land trust. When you have a land trust, the only property that is held by the land trust is that one piece of real estate. When you have a living trust, you can transfer anything into that living trust. So it's a much more flexible tool. You can transfer financial accounts into your living trust, as many pieces of property as you want. With a land trust, it can only hold one piece of real estate, one parcel.
Okay. Well, Denise, thank you for joining us, and could you give them your information if they wanted to contact you?
Sure. So the best way to contact me is through email, which is drusso@salvifwifler.com. And then office phone is 847-438-6153.
And I really appreciate you for coming on and teaching my viewers something about that, because I really do stress to them all the time. And especially my clients as well, buying multiple properties and letting them know what the importance of securing their assets when they have that generation. They don't get probate debated or falling out with their children falling out with each other because one felt like, I should have got this one to have more.
Yeah. Well, thank you so much, Tiffany, for having me. I really appreciate it.
Okay. Have a nice day.
Take care. Bye.